Welcome to U.S. Immigration TV. Now, in previous videos, I discussed immigration proposals by the Biden administration, such as the U.S. Citizenship Act of 2021 for undocumented immigrants and the Dream and Promise Act for DACA children. Now, those proposals are still pending in Congress, and we hope some form of immigration reform will pass and become law. However, as we know, many times in the past, there were immigration reforms proposed, but they didn't go anywhere. In the meantime, are you wondering if there's anything you can do right now while waiting for immigration reform? Well, the answer could be yes. And to know what you could do right now for your family, make sure to watch this video until the very end as I explain the steps and existing immigration benefits you may already be eligible for and may not even realize it. Now, before I get into benefits that could be available now, the very first thing you should do for any proposed amnesty is to start gathering your entry documents, such as your entry visa, and proof of being in the U.S. before January 1st, 2021. You should also consult with an attorney if you have criminal issues or convictions, or if you've had previous filings, denials, or deportation or removal orders. Many times, I've had clients who've waited for a long time and sat on their cases. Don't wait for the last minute when there's a mad rush to file or apply. Already ask for help in requesting for your immigration files and in analyzing your situation so you're already prepared. Now, here are 7 benefits or laws or possible ways that you may be eligible now without the need to wait for amnesty or for immigration reform. Number 1, Section 245I. Now, Section 245I was a law that expired April 30, 2001. So it's gone. But what that law allowed is for people to still be able to apply for their green card or adjust status in the U.S., even if they're out of status, work without authorization, overstayed, provided that they were petitioned before April 30, 2001. So let's say maybe in 2000 you were petitioned by an employer, but the case didn't go anywhere. The employer backed out or whatever. And now, today, you have a different way to get a green card. Well, you could still possibly be eligible to apply for a green card in the U.S. if you were what's called grandfathered under Section 245I. Another available benefit today is provisional waiver. Now, if a person is not eligible to adjust in the U.S., they could apply for a provisional waiver. Now, a provisional waiver is where, as I say, you're not eligible for some reason to apply for a green card in the U.S. You have to go back to your home country. But if you leave the U.S., you could be subject to a 3 or 10-year bar. The provisional waiver is basically you ask for forgiveness or a waiver of the 3 and 10-year bar in the U.S. before you leave the U.S. And you should definitely see an attorney to see if you are qualified for the provisional waiver or eligible or whether you need it or not. Now, it takes about a year to process a provisional waiver. And of course, even if it's approved before departing, we want to make sure that the embassies are fully open and operational and accepting cases for visa issuance. As you know, they are only just now beginning to open up, and you don't want to fly back and get stuck there in the meantime. Another available option today without immigration reform is a joint motion to reopen. Now, ordinarily, if a person has been ordered deported or removed, it's really difficult to be able to legalize their status, especially with that old deportation or removal order on their record. In fact, they cannot even file for adjustment of status in USCIS if they have an old removal order. You know, maybe many years ago, a person was put in deportation, but they really didn't have a form of relief available at that time. But maybe now they married a U.S. citizen who wants to petition them, but they still have that deportation order. Sometimes the trial attorney, who's like the prosecutor for the government, would be willing to join in a motion to reopen the deportation case and have it dismissed enabling a person to go forward and file their case with the USCIS and adjust status here in the US. Now, of course, under the Trump administration, they were very strict and trial attorneys would not agree to join in any motion to reopen. However, under Biden, it is coming back. In fact, in my office, just last week, we negotiated with the trial attorneys and they agreed to join in a joint motion to reopen our client's case because he had the old deportation order. Now he's married to a U.S. citizen. So he would be able to pursue his case. So if you have an existing deportation order but now have a new way to possibly attain a green card, you should see an attorney. Another benefit that is still available today is to file a new waiver. Now, sometimes people previously filed a waiver, let's say a fraud waiver or a hardship waiver, but it was denied for some reason, such that they didn't make a convincing showing of extreme hardship to a qualifying relative. Now, it could be possible to file a new waiver that is better packaged and presented, especially if the qualifying relative has new hardships, maybe has a new ailment or something like that. And I know in my office, many people have come to my office with denied waivers, but we were able to refile a new waiver with a more convincing presentation, and we got the waiver approved, and they were able to get a green card. Another existing benefit today without immigration reform is cancellation of removal. Now, it could be possible for a person to apply for a green card if they've been in the U.S. for at least 10 continuous years, they are of good moral character, and they demonstrate that they have a U.S. citizen or immigrant parent, child, or spouse who would suffer extreme and exceptionally unusual hardship if they're sent back to their home country. That's called cancellation of removal. Of course, with cancellation of removal, you have to apply in front of a judge, so you would need to be in removal proceedings. But if you are already in removal proceedings right now and you've been here for 10 years and you can show that hardship, it could operate as a defense in your deportation case. Another existing benefit or avenue to legalization that is available today is to refile a marital petition that was previously denied. Now, sometimes a person marries a U.S. citizen for love and is petitioned by that spouse, but the case is denied because maybe they did not demonstrate the marriage was bona fide. For some reason, the USCIS thought it was a fixed marriage. It could have been that the couple was truly in love, but something happened at the interview. Maybe they got nervous, their answers did not match, or they didn't have enough supporting documents to show that this was a real marriage. There could still be hope, and the case could perhaps be refiled along with a better presentation and packaging of the case to show it was a bona fide love marriage. Even if a person was previously found to have been in a fixed marriage and they are now married to a new U.S. citizen, as long as they can prove the first marriage was real, there could possibly be hope. Another benefit you may be eligible for is what is called a sua sponte motion. Now, ordinarily, there are filing deadlines to bring motions to reopen or motions to reconsider. However, if you are past those deadlines, but it's clear that the USCIS made a mistake, it could be possible to request that the USCIS reopen or reconsider their denial on their own. That's what's called a sua sponte motion. Now, of course, I'm not guaranteeing that these forms of relief apply to you, or if they're filed, they will be granted. That's because attorneys cannot guarantee results. And most important, before you file anything, you should consult with an attorney who can evaluate your case to make sure you are qualified. But this goes to show that even now, without any form of new amnesty, there still could be ways by which a person could possibly legalize their status. That's why I would advise you consult with an attorney who can evaluate your case and determine if you could be eligible for any existing immigration benefit now. And of course, the attorney could assist in preparing the necessary paperwork, gathering the documents, which could greatly increase your chances of success. Now, we will continue to monitor developments in immigration law and reform and post videos to keep you informed. So don't forget to like, share, and most important, subscribe to this channel so you're kept updated on the latest developments, not only for new legislation, but also perhaps for ways you can benefit from existing laws. Now, I'm Michael Gurfinkel. Thanks for watching, and this is U.S. Immigration TV.